I have a comment. No. Oh, there it is. Only it. Do you miss this? You're bad. Wow. Well, I've been on the course 7 years, so maybe it's time. Thank you. It's good. We really appreciate your help. Mr. Isaacs, let me know when you're ready, okay?
Are you ready, sir? You ready?
No, Council. I need to get the high sign from the bailiff here. Thank you. Thank you, Council. We appreciate that. We were just going to let you guess.
Or just keep talking.
Yeah. We're here in our case 1CA CV19-0112, Quintana Suarez versus Chazeras. Each side will have 20 minutes to present their argument. Appellant, you may reserve any amount of time for rebuttal that you want, but you'll have to keep track of the time yourself. That's all we have the clock at the podium. We are recording this argument. It's streaming on the internet. I think it will come out in YouTube in a couple of days. Because we're recording this, when you approach the podium, please identify your client and yourself so that we can keep everybody straight when we review the recording. We've read the briefs and the record and we've conferenced the case, so we're familiar with the facts and the issues. So when you begin your argument, just start with what you want to talk about. Counsel, you may begin.
It looks like I have one extra second.
That's okay.
All right. May it please the court, my name is Mike Helms. I represent Reina Quintana Suarez, who appears for herself and as mother and next friend of Lena Mendez and Sorelli Mendez, her children, and also on behalf of Michaela Suarez, who happens to be the mother of Reina. This was an automobile accident that occurred back in 2016. It was a rear-end accident in which the defendant has admitted responsibility for causing the accident, and so the only issues that we went to trial on were the injuries and damages claimed by the plaintiffs. It happens that the jury returned a verdict for the defendant, and in order to do that, that would have required either that the defendant was not responsible for causing the accident, which he admitted, or that no one was injured in this accident. None of the four plaintiffs or four parties were injured in any way as a result of this accident. So we're really going to talk about the injuries. Dr. Gardner is a chiropractor.
So what was the standard of review on your claims?
Standard review is whether there was error in either the admission, which is a big issue in this case, the admission of certain testimony, or if there's a clear error in whether the verdict is supported by the evidence, which we believe it is not. The issues here are that Dr. Gardner was the only one.
Is it a jury trial, counsel?
Pardon?
Is it a jury trial?
This is a jury trial.
Okay. Go ahead.
Dr. Gardner was the only witness in this trial who ever examined any of the parties, any of the injured parties, who ever treated any of the injured parties, and testified that their injuries, which were orthopedic injuries, muscle sprains and strains, were caused by the accident, and he treated them for that, and they had good recoveries as a result of his treatment for them. The other side of whether or not these injuries were sustained was presented by the defense, and they had two witnesses. One, a biomechanical engineer, Mr. Manning, and the second, a Dr. Levine, a neurosurgeon. Now, Mr. Manning testified that he calculated the speed of the vehicles that impact that caused this accident, and then he testified that at that speed, this would have been such a minor accident that injuries would be unlikely at all.
Well, and counsel, why isn't the jury entitled to give more weight to that testimony than the testimony of the doctor?
Because there was no foundation for that testimony, Your Honor. That testimony should have never been admitted. It was objected to on foundational grounds. Mr. Manning testified that he calculated the speed of the vehicles based upon photographs of the vehicles.
So your argument about the lack of evidence then depends on the ruling on the evidentiary issues. If the trial court was correct on its evidentiary issues, then you lose on the weight of the evidence issue, correct?
No, Your Honor, because the defense acknowledged these injuries. Dr. Levine
Injuries or fault?
Pardon?
Acknowledged injuries or fault?
Both.
And how
Dr. Levine did. Now, let me talk about we can talk about Dr. Levine to begin with. Dr. Levine was subject, first of all, to a motion in limine that said he cannot testify about the reasonableness of any of the treatment that was provided for these parties. And yet, he was presented as a witness to specifically talk about the reasonableness of the treatment for these injuries. That was told to the jury by counsel.
Well, but counsel, that's how I understand the record. I thought that doctor said that the surface EMG cannot reliably detect pain, which is a different matter than reasonableness.
He talked about, that was what most of his testimony was about, was whether or not this surface EMG should have been done or was reasonable to have been performed, whether it was valid, and that's just not an issue for the jury to decide. It's not an issue because it is not up to the defendant to decide what treatment the treating professionals are going to provide. And there is no rule of law in Arizona or elsewhere that says the defendant who causes an accident and causes injuries gets to decide what kind of treatment you get or what kind of treatment you don't get.
But they can present evidence on the validity or the efficacy of the treatment, can't they?
To a degree, but not like this. In this case, it's what's reasonable is reasonable for the plaintiff, not for the doctor.
Well, it seems like whether it's reasonable to seek treatment, it's a different question than whether the treatment that they received was valid or efficacious. And I read the record that Dr. Levine's testimony went to the second issue and not the first.
The defense doesn't get an opportunity to challenge whether the treatment that was received by the plaintiff. Plaintiff's treating professionals decide that. And even if the plaintiffs pick somebody who malpractices, the defendant is still liable for that. It doesn't, and if they want to claim that there was some additional damage, in this case, additional medical expense caused by some examination that they think was unreasonable, then their obligation under both the Transcon Lines case and the Kramer versus Starr case is to name that person as a non-party as at fault and proceed under that. None of that was done in this case. Both Transcon Lines and the Kramer versus Starr say that under the OTR, the original tortfeasor rule, an actor who negligently causes an injury that reasonably necessitates medical treatment may also be liable for any enhanced harm approximately resulting from the actor's negligence, including subsequent injury and related damages negligently caused by a medical practitioner. And to avoid that, they've got to do a non-party at fault. Both Kramer.
If what they're challenging isn't that it was additional harm, but it was medically necessary, isn't that a difference?
No. It's really not. What it is what's reasonable. Is it reasonable for the plaintiff to follow the advice of their medical professionals, or is it not? Did the medical professional make some bad advice? That's what the argument is in this case. They're arguing that the medical professional, Dr. Gardner, should never have ordered that surface EMG because it just doesn't work. It doesn't tell you anything. And they put on evidence that would suggest that. Dr. Gardner and Dr. Vink testified on the opposite side of that, and the jury could find that either way. But that's really not an issue for the jury.
Counsel, the court ordered that Dr. Levine can offer an opinion about the causation or the reasonableness of treatment, but could offer his opinion on whether the treatment and tests were medically necessary. Is that not correct?
I don't know how you really get a separation of the difference between necessity and reasonableness. But assuming that there is, What this testimony was offered for was for the purpose of determining reasonableness.
But and isn't it for the trial judge to make that determination, because it is his order that the expert can talk about the reasonableness, but can talk about whether it was medically necessary. So isn't it up to the trial judge to make that call? And how can we say that that's wrong?
Once the trial judge makes that decision and says you can't talk about reasonableness,
But you
that this
can
witness, but you can talk about necessity. But when counsel gets up and tells the jury he's coming on to talk to you about reasonableness, that is grounds for mistrial. And that's when we made the motion for mistrial when he did that.
And why did the trial court rule?
He just thought it wasn't bad enough.
Then
I don't know.
Then by what standard do we say that the trial judge was wrong?
Because the trial judge was wrong because he was specifically testifying about reasonableness. The jury was told that this testimony should be considered about reasonableness, and they were told that in the opening statement of defense counsel. That's what's wrong. This jury had that throughout this case and from the beginning of this case. Notwithstanding that, Dr. Levine acknowledged that there were injuries here, and the jury really had no basis for saying there is no liability, no injuries in this case.
So,
Dr.
counsel, you're
Levine-
saying there was that's the standard, no evidence in this record to support the jury's verdict?
That is correct. There is none, because Dr. Levine, who never examined the plaintiffs, never treated the plaintiffs, reviewed only the medical records, and then testified there is no neurological injury here. The same thing that Dr. Gardner said in his records. Said there's no neurological injury, but there is orthopedic injury. And even Dr. Levine agreed there is orthopedic injury, and he agreed that there are objective findings of orthopedic injury. He said, yeah, that the records show there's a misalignment. The records show there are trigger points, there are fixations, all of which are objective and which would be objective findings of orthopedic injury.
But there was testimony that the collision was at such a low speed that there would now be injuries, correct?
There was testimony that should never have been presented to the jury, and that was Mr. Manning.
And why not?
Because he had no foundation for that. His opinion was based upon photographs and his estimation of the damage that appeared in those photographs. But Mr. Manning testified that he didn't take the photos. He didn't know who took the photos. He didn't know when the photos were taken. He did not know if there were any repairs made to either of these vehicles before the photos were taken. He did not know if the photos depicted the condition of the vehicles immediately after the accident. And he had never examined the vehicles. All of that testimony is on day 3 of the transcript, page 185. And Mr. Manning acknowledged all of that.
You objected to the testimony.
I objected on foundational grounds.
And the argument was that these are the kinds of things that biomechanical experts look at in coming to their conclusions.
No, Mr. Manning testified that he was basing his opinion that there couldn't be injuries from this kind of an accident, having calculated the speed of the vehicles without any foundation for doing so. But then he says, based upon published reports of other kinds of accidents, no injuries could be caused, or is not likely to be caused by this case. But he made no comparison whatsoever to show any similarity between this accident and any of those published reports, which would have been a foundational requirement.
And why did the trial court rule?
Pardon?
And why did the trial court rule on that issue?
Overruled my objection on foundational grounds. Simply overruled.
Okay.
So, Counselor, you're saying there were only two points of evidence introduced to suggest the jury's verdict. One was the testimony of Levine, but that actually supports your client. He agreed that your client was injured.
Correct.
And the other one is an engineer that should have been excluded, and there was not any other evidence. How long was this trial?
It was 3 days.
3 days. No evidence presented in those 3 days to support the jury's verdict.
That is correct. The testimony of Mr. Manning should not have been permitted. The testimony of Dr. Levine, even if permitted, which I suggest it should not have been permitted because it was in violation of the motion in limine. But even if permitted, he acknowledged these people were injured, orthopedic injuries, not neurological injuries. His testimony, 90% of his testimony was talking about the surface EMG, and that was really what he was called there for, was to challenge the expense of that surface EMG, which is a relatively minor expense in the treatment of these people. I'll reserve the rest of my time.
Thank you, counsel.
Good morning, Your Honors. My name is Christopher Robbins. I'm with my partner, Tom Hall, the trial lawyer. On behalf of the defendant, appellee Walter Chazeras. I don't know quite where to start with all of that. Judge Weinsweg, you asked about evidence. The plaintiffs themselves at the scene of the accident said, "We're not injured, we're okay, we're fine." They told that to our client for an hour and 15 minutes. They told a passing firefighter who had stopped to check on everybody, they said, "We're fine, we're okay, we're not injured." When the police arrived, they said that. They didn't stop at urgent care or emergency room on their way home. They don't even seek any treatment whatsoever until 4 or 5 days later, when they go to a chiropractor who had happened to help the grandmother successfully recover some money in a previous lawsuit.
Counsel, what happens if we disregard Dr. Levine's testimony and the testimony of the biomechanical engineer? So if we throw that evidence out, a jury could have disbelieved the plaintiff's testimony at trial that they were injured based on the earlier statements.
Your Honor, you can throw all of that out, but the standard of reviews that you were trying to get from opposing counsel define this case. The judge did not grant the motion for new trial, he denied it. And in that situation, the appellate court inquires whether substantial evidence exists to support the trial court's order, resolving every conflict in the evidence in support of the order. In regard to the admission of the expert testimony, the trial court has supreme discretion in resolving that issue, and they will not, this court will not overturn the trial court unless such determined as a clear abuse of discretion and there is resulting prejudice. This was a nothing accident, Your Honor. There were no injuries. The photograph, a picture is worth 1,000 words, they say. We attached the photographs of the rear of their large SUV to our brief. You can barely see a mark there. Walter's car, smaller car, slid under the bumper, did a fair amount of damage to his hood, but nothing to the other car.
Counsel, my question was, even if we would agree that the biomechanical expert's testimony was improper and that Dr. Levine's testimony was improper and shouldn't have been considered, was there sufficient evidence of the inconsistency between the plaintiff's trial testimony and their earlier statements for a jury to find that they were injured?
Absolutely, Your Honor, and I'll talk in a moment about why it was not improper to admit both experts. But absolutely. If you are injured in a car accident, you know it right then. You know that you have cuts, you know that you have bruises, you know that you have torn muscles, you know that you have a broken bone. It's just as if you're running and you sprain your ankle. You don't wait 3 days and say, oh, I sprained my ankle the other day. You know it right now. They offered zero objective evidence of any physical injury. They had subjective complaints of pain. Their chiropractor recognized what a weak case they had and tried to objectify it by getting the surface EMG, which is, there is no pain meter. There's no such thing as a pain meter. Dr. Manning absolutely, Dr. Levine absolutely has the foundation and credentials to say that that has no validity, no efficacy, has not been recognized by anybody. And it just makes sense, Your Honor, that we cannot attach a little electrode to ourselves and measure pain.
So
Because that is
I'm
the...
not
Okay.
used to delving into the record, but what about this point that Dr. Levine actually supported your colleague's case?
No, that's not true. What Dr. Levine said is if they had any strains or sprains, conservative treatment, by which he meant not chiropractic, physical therapy, pain injections, anything like that. What he meant is if they went home, got some rest, took an over-the-counter pain medication, took a hot bath, they would have resolved, and they would have resolved without any intervention by any provider whatsoever. That's what he was saying. He was saying, take them at their word that they have pain. This is what you do. Take 2 aspirin and call me in the morning. You'll be fine. First, Dr. Manning's opinions are easy to resolve because there's controlling case law in Arizona, the Lohmeyer v. Hammer case and Munguia v. Kramer. Manning's opinions were not based solely upon photographs as they would have you believe. He based it on his extensive experience, education, training, the mechanical specifications of the vehicles, the accident report, the photographs and repair estimates, which Lohmeyer recognizes are valid grounds. He did his biomechanical, or the damage to the vehicles, volunteer studies, crash test dummy studies, the literature, everything that an expert uses to offer an opinion. He refers to something called MER, MER, and unfortunately I don't have the expertise to discuss that with you right now. I should have. But he didn't just look at photos and said, oh, they couldn't be hurt. He did exactly what this court permitted the biomechanical engineer in Lohmeyer and in Munguia to do. And he said, when you look at all of that, when you look at the forces applied in here, which are comparable to just walking, sitting back in a chair, riding in a bumper car at an amusement park, everyday living activities. If you look at that, there is no mechanism here for injury. Nothing in this accident could have caused injury to these people. Now, they make a big deal about Manning would not say absolutely positively you could never ever, it's impossible to ever have a serious injury with this minor an accident. And that's true. Manning is a scientist. He will not ever say anything is impossible. But based upon everything, it is so manifestly improbable that it would happen to one person, let alone four persons, four people in the same car, that it didn't happen here. And if it did, plaintiffs failed mightily in presenting evidence to carry their burden of proof of injury. The plaintiffs actually went to a nurse practitioner, the only medical professional that ever saw them. She found nothing wrong with them. This is the person that her chiropractor sent her to because his adjustments were causing them additional pain. So he said, go see the nurse practitioner. And she says, I don't see anything. I don't see any objective evidence of injury. I'm not even going to prescribe any medication. I don't recommend any further chiropractic treatment. They've just ignored that. I mean,
Did the
that's
nurse practitioner testify?
through deposition, I'm told. Through deposition, Your Honor.
I think our medical record.
And also, and certainly, I believe Dr. Levine went through her medical records because he noted that the inconsistency of everything here.
But that information was relayed to the jury?
Yes, they when the chiropractic treatments were actually causing additional pain, the chiropractor said, well, I have this nurse practitioner that comes in here, and so, see her as well, and she could not find anything. The argument about Walter being responsible for all the damages and not having any voice in who they choose as a medical provider. Well, of course the defendant doesn't get to say who they can go see. That's a given. We understand that. But they're putting the cart before the horse, because before they talk about whether Walter can be liable for whatever the doctor did or anything else, they first have to show that he's at fault. And at fault is defined in 12-2506 F2. And it says, he was at fault, which means that he proximately caused injuries. We know from both Manning and from Dr. Levine that he did not cause any injuries. Before they move into any of that information, which and their Transcom case is completely outdated, a 1972 case that has basically been overruled. Kramer versus Starr basically says we're not going to have contribution anymore because we only attribute to each defendant in proportion to that defendant's fault. And I've basically run out of material, Your Honors, because this one is just such an open and shut case, and it's will be decided by the standard of reviews. And so unless Your Honors have questions,
I was going to say, with respect to the record, as he refrains, in closing argument, there were objections about characterization of Dr. Levine's testimony.
oh, thank you, Your Honor. I completely skipped over that. The earlier motion in limine was sort of a nuanced ruling that I'm not quite, I understand. It was by the preceding judge. And he said, you've got Manning talking about causation, so I don't want Dr. Levine talking about causation. And somehow he rolled reasonableness into that as well. But he says explicitly, Dr. Levine can testify about the necessity of the medical treatment. And then he says in his minute entry, and defense counsel can say, well, if it was not necessary, then it's not reasonable to go get that treatment. That's all that happened, Your Honor. And there's just the overwhelming weight of the evidence showed that plaintiffs were not injured, that the medical treatment was not necessary and therefore not reasonable. There was no causation here. The jury could have found on any one of those bases, could have reached its decision and returned a defense verdict. There's really nothing to consider here. My partner's telling me he's not sure he took the nurse practitioner's deposition, so we want to correct the record on that. And
Thank you.
but
We know the records.
Dr. Levine positively talked about her.
Thank you, counsel.
Any other questions, Your Honors? Thank you very much.
Thank you. Counsel?
There were 4 people who testified about whether there were injuries here or not injuries and what those injuries were. Raina, Michaela, both testified about their injuries and the injuries to the children. Dr. Gardner testified about that, and he said that those injuries that he treated were caused by this accident. And Dr. Levine agreed that there were orthopedic injuries here. He was testifying simply that there were no neurological injuries, which Dr. Gardner didn't disagree with. He had that in his records, there was no neurological injury.
Counsel, there were statements made at the time of the accident and shortly thereafter that everyone was okay, there were no injuries. Couldn't the jury believe that they were telling the truth then and not now?
Both Raina and Michaela testified that their pain started the next day, got worse over the weekend. They called for an appointment on Friday. Because of the weekend, couldn't get in until Monday. So there's the 5 days, but their pain just kept getting worse and worse and worse.
But the jury gets to determine credibility, and they could have not believed them.
But they also have to base it on evidence, and that testimony was the only testimony about that. And then Dr. Gardner also testified that it is normal for these kinds of injuries to have manifested themselves in the next few days after an accident, not at the time. Incidentally,
And so that would be, and they could, Could they also look at the nurse's records, there was discussion about the nurse's records, and had that impact them?
The nurse didn't see them until several weeks after this accident, say, several weeks after they had been treated by Dr. Gardner. And she never saw two of these parties, never saw the children.
She saw the adults.
Lena and Sorelli. In fact, Dr. Levine never mentioned any of the children. So the children, the only testimony is from their mother and from Dr. Gardner, and that testimony was uncontroverted.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and issue a decision in due course. Thank you. We stand adjourned.
Chris Robbins, we didn't introduce
Chris, I don't
ourselves
think we've
beforehand.
met before.
No, I don't think so. Time flies, doesn't it?
Oh, God.
When you're standing there.
I'm ready to
But you're not, you just got another one.
Oh, we keep John and
With these same docs.
Oh, of course.
Gardner and Bank, sure, I mean, we may as well just go retry it.
I'm sure you would.
Although I think we would just accept the
Yeah,
other.
you did.